remember the information. Juliana did not know the password to Christine's phone, the laptop, the email account, the Telegram, or the FetLife accounts. She did not even know the name of the email account. How could she have accessed it without any of that information? Juliana claimed that she wrote messages but could not identify a single message that she wrote. Juliana said that the Gmail was created on the laptop when it was created on the phone, then said that I deleted the two-factor authentication, which was never deleted, never hidden, was still there. The Telegram application was also not hidden, always available on Christine's laptop. It was never uninstalled and reinstalled and was always available. When Juliana was questioned about the email account, this is her quote. "I was not the one logging in. It was Brendan who accessed the email. The question was then restated and resent and said again, and this is her second quote. I was not the one logging in. The email account was accessed approximately 10 times while I was not home. This includes when I was in Maryland at FLETC, a secure government facility that required an appointment and ID verification to enter. If Juliana did not enter these email accounts, but they were still logged in, there's only one other person that could access these accounts, and that is Christine. There are also two instances where neither Juliana or I were home with the logins. This includes the morning of 2/24, when I had left for work and was seen on video at McDonald's, and Juliana had left the house. Her movements were tracked and verified by GPS. Her phone logged that she was parked in the cul-de-sac, and her Apple Watch had logged her steps leaving the home. And by her own testimony, she also stated that she had left the home. Yet after that, the laptop was then logged in and accessed again. There is no dispute that Joe Ryan brought the knife to my home. My DNA and fingerprints are not on the knife. Joe Ryan's DNA is on the knife, right at the junction of the handle and the blade. The DNA is right where you would expect it to be for someone who is forcefully using the knife. This is further verified by the injury that is on Joe's thumb in his hand. The medical examiner verified the injury on Joe's thumb could be caused by the knife. There are no injuries to my hands, nothing to indicate I ever held the knife. Joe's DNA is also under Joe Ryan's fingernails. Sorry, Joe's DNA is also under Christine's fingernails, indicating that she tried to fight him off. Joe Ryan's hands have a mixture of Joe's and Christine's DNA. When he got back up and struck me in the back, it was transferred to the back of my jacket. Juliana's original statement on 2/24 stated that I never touched Joe. She repeated this again in both of her proffers and at trial. The prosecution has repeatedly said that I manipulated the scene and moved Joe Ryan. I never left Christine's side. I only tried to render aid to her. Juliana said that I poured blood on Joe. This does not match the findings of the medical examiner or the blood spatter expert, who described that these were transfers and were not as droplets. Christine obtained tickets to the zoo and sent them to Juliana. There was no prompting for this. Christine wrote the zoo on the calendar and in Juliana's schedule. Only Christine could have planned the meeting on 2/24. The meeting of Christine and Joe was confirmed over a week prior, but only Christine could have chosen 2/24 because she was scheduled to work. No one else would know that this day would be available. On 2/24, she had only requested off from work on February 23rd and had not informed anybody else that she was off until then. The Fairfax County Police Department never truly looked into Joe Ryan. No search warrant was ever conducted at Joe's residence. Only two women were interviewed about their relationship with Joe, and both found that they were very uncomfortable with him. Both chose not to see him again. One was so uncomfortable that she went to her therapist the next day. These are her quotes. She felt so out of place, and that it was dirty, and that he was uncomfortable towards her. I believe only one of Joe's friends was also interviewed. He stated that in a confrontation, Joe would choke or strangle somebody. This matches Joe's social media profile, saying that he studied neck snapping at Harvard. And to add to that, where was Christine stabbed? In the neck, which Joe seems to have a fondness for. These things are some of quotes from other people, not from me. Joe had previously also cut another woman. It's in his own messages, in his own words, that he was attracted to that. Separately, there's entire internal affairs videos about this case. So either Detective Bryant or Lieutenant Giacchio is lying based on what they said at trial, because Lieutenant Giacchio denied saying that Juliana was arrested as an innocent. Meanwhile, Detective Bryant said that was brought up to him by Giacchio in his internal affairs video. Both of them are under oath. So one of them would be committing a Giglio violation. Also, Detective Nielsen stated that Juliana was arrested to get her to flip, and there was no other reason provided. Christine was a wonderful and loving person. Just as you heard from many of the people here, she was a loving and compassionate nurse. During COVID, she volunteered to take care of many of the people that were sick and struggling. She signed up for extra shifts. She signed up for vaccination clinics. She cared for her daughter. She enrolled her in dance lessons. She was there for recitals. I loved her very much, despite what you may think of my affairs. Our marriage worked for us. It wasn't something that I looked to end. It was told to other women that I was never going to leave Christine. That was always how it was said. Christine cared very much for her family and friends. I'm not trying to diminish in any way what her life was. She truly was a caring mother, a caring wife, a loving nurse. But I am not responsible for her death. This is not a knife that I ever held in my hand, and I never stabbed her. Thank you.
All right, Mr. Banfield, a jury of your peers, after hearing all the evidence, has found you guilty of count 1 of the indictment 2024-666, aggravated murder of 2 people in the same act or transaction. They found you guilty of count 4 of 2024-666, aggravated murder of 2 people within a 3-year period, count 5 of 2024-666, use of a firearm in the commission of a felony, and count 1 of 2024-873, child endangerment. In accordance with Virginia law, although you have been found guilty of 2 counts of aggravated murder, the court can only sentence you on 1 count of aggravated murder, which will be count 1 of 2024-666. The statute requires a sentence of life imprisonment on this count, which is now the highest penalty one can receive in the Commonwealth of Virginia. This exact statute was our capital murder statute until Virginia abolished capital punishment in 2021. You should understand you were found guilty of crimes that 5 short years ago would have carried a sentence of death. That reflects the severity of your crimes and your actions. Life in prison is a punishment reserved for a very small number of individuals. Those whom the community has determined should never walk free again. It is a harsh sentence, but in this case, it is a justified one. In the 18 years I've been on the bench, I have seen hundreds of defendants appear before me, and I've had the arduous task of sentencing these individuals. In the vast majority of these cases, people made mistakes, were struggling with substance use disorders, or acting in anger, choosing violence in a moment that changed everything. They were not inherently bad people, but they made terrible decisions and suffered the consequences. Sentencing in those cases is difficult. It weighs on me, often long after the hearing is over. Only 2 times prior to today have I encountered something different in my courtroom. 2 individuals that carried no remorse, calculated, and planned their violent crimes and left many victims and devastation in their path. As I listen to the evidence in this case and listen to your testimony, it is apparent that I am once again looking at that same kind of evil. The disregard of the life of your wife, someone you supposedly loved, is almost unfathomable. Scheming for months a master plan involving so many moving parts, including deception and manipulation, luring a completely innocent man into your deadly trap, continuing on after the murders without a care, and not once thinking of the impact on Christine's daughter, the unspoken tragic victim of your behavior. You did not just take her mother from her, you placed her in the middle of the horror you created. She is young now, but one day she will understand your true self, and she will understand what you took from her, which is everything. The loss of her mother, who will never be a part of her life as she grows, the loss of her family and the security she lived under. All of this is lost based on your calculated and selfish behavior. It is impossible to comprehend what Joseph Ryan experienced, seeing you enter the room, being shot in the head, blinded, hearing you instruct the co-defendant to shoot him again. And Christine, to imagine her final thoughts as she initially thought you were there to save her from what she thought was a brutal attack, and then to see you over her stabbing her again and again with a knife in her neck, her final realization that this was all you're doing, and in her final moments thinking of her daughter. The sentence I impose today reflects not only the law, but the judgment of the community. The jury did not find you credible on the stand. To testify as you did shows the court that you still think that you are the smartest person in the room. One would hope that someday you will become tortured by what you have done to Christine, Joe, Christine's daughter, and their families, but nothing I have seen suggests that you will. The level of cruelty, calculation, and inhumanity in this case reflects something far deeper than anger or impulse. It reflects evil, which is why I carry no burden and find no hesitation in sentencing you to life. On count 1 of 2024-666 aggravated murder, I sentence you to life in the penitentiary for the rest of your natural life without the possibility of parole, without good conduct allowances or any earned sentence credits or conditional release. On count 5 of 2024-666, use of a firearm in the commission of a felony, I sentence you to 3 years in the penitentiary, which is a mandatory term and cannot be suspended. Since it is required by statute, an additional 6 months is ordered and suspended for post-release probation, which is a nullity in this case, but is required to be part of the sentence. On count 1 of 2024-873, child endangerment, I sentence you to 5 years in the penitentiary. Since it is required by statute, an additional 6 months is ordered and suspended for post-release probation, which is again a nullity in this case, but is required to be part of the sentence. Each of these sentences are consecutive, that is one after the other. And since you've been convicted of a felony in Virginia, a sample of your DNA will be taken and submitted to the Virginia State Police database. That is the sentence of the court. Are there any questions, Mr. Carroll? Any questions?
No, Your Honor, but the Commonwealth does have one additional request, if I may.
Yes, ma'am.
The Commonwealth is asking that a condition of the sentence be that the defendant have no contact with his daughter, Valerie. This is at the request of her guardian ad litem, her therapist, and her counsel.
I understand, but I'm not doing any probation, so how can I do a no contact order?
Judge, I think with the 6 months of post-release, same action, even though there is no likelihood of those 6 months ever being imposed, they are suspended on the condition as required by statute. This condition would operate similarly.
But that would only work for those sentences, correct?
That is correct.
I mean, I can't order him no contact if I'm giving him life in prison.
Understood, Judge. I'm making the request.
All right, I just
Thank you.
deny that request. Thank you. All right, Mr. Banfield, you have the right to appeal a decision of this court. You must note your appeal within 30 days of the final order of this case. It is my understanding that Mr. Carroll will not represent you on appeal. Is that correct, Mr. Carroll? All right, so sir, Mr. Banfield, do you wish to hire your own attorney or have the court appoint you an attorney?
Hasn't been decided.
I'll go ahead and appoint an attorney for you now. If later on you decide to hire your own attorney, you can do that. Okay, sir?
Sure.
All right, since Mr. Carroll told me of his intentions in advance, my clerk was able to find an appellate court appointed attorney who is willing and able to take your case. So the court appoints Brandon Sloan as your appellate attorney. The court ordered transcripts of the trial back in May, so those should be available now for your attorney to review. So there should be no delay in your appeal, okay? Mr. Sloan, I'm sure we'll come see you in the next few days. All right, sir?
Yes.
All right, is there anything further in this matter? All right, you're a man of the custody of the sheriff. Thank you. And Ms. Gill, I'm going to take a 10-minute recess and I'll come back and finish the rest of the sentencing docket, okay? All right, anything further, Ms. Sands?